Testaments in Argentina. Here's everything you need to know about Argentine wills. In Argentina, testaments or wills are legal documents used for transferring assets and designating beneficiaries after the testator's death. Argentine inheritance law is governed by the Civil and Commercial Code, which outlines the rights, formalities, and limitations surrounding testamentary successions. Here's an overview of the main aspects of Argentine testaments. 1. Types of testaments. Holographic wills, or Testamento Ológrafo, is a handwritten will written entirely and signed by the testator. It doesn't require witnesses, but must be handwritten by the testator to be valid. Now, public wills, Testamentos Públicos, are wills created with a notary present and signed by the testator, the notary, and witnesses. It is registered in the public notary records and offers more security. Closed will, Testamento Cerrado. This will is handwritten and sealed by the testator and then delivered to a notary in the presence of witnesses. It remains closed until the testator's death. Foreign will. Argentina generally recognizes valid foreign wills if they meet the formalities of the country where they were made. However, such wills must be translated and legalized for use in Argentina and be verified by a court of law. 2. Limitations on testamentary freedom. Argentine inheritance law includes forced heirship rules limiting the testator's ability to freely distribute their assets. Certain family members, known as forced heirs, legitimarios, are entitled to a statutory portion of the estate which cannot be overridden by a will. Forced heirs include spouses or cohabiting partners, children and descendants, parents and ascendants if there are no descendants. The estate is divided into 3 portions. Legitimate portion reserved exclusively for forced heirs. Available portion, this part of the estate is freely disposable and can be left to anyone the testator chooses, even a relative. Now, improvement portion, this is a discretionary portion that can be given to any of the forced heirs to improve their shares. 3. Requirements for validity. Capacity. The testator must be over the age of 18 years old and possess mental capacity when making the will. Voluntariness. The testator must be acting voluntarily, free of coercion. Formalities. Each type of will has special formal requirements, and failing to follow these requirements may lead to the will's invalidation. Wills must be notarized or satisfy other formal requirements depending on the type. This ensures authenticity and legal recognition. 4. Revocation and alteration. Argentine law allows testators to revoke or amend their wills at any time, provided they maintain mental capacity. The most recent valid will supersedes any prior ones. A will is automatically revoked if the testator makes a new one clearly stating their intention to cancel any previous versions. 5. Probate process. After the testator's death, the probate process, sucesión, administers the estate according to the will's terms, or if there's no will, follows the general rules of intestate succession. The process includes filing the will is presented to the probate court for authentication, appointing an executor. If an executor was named, they manage estate administration. If none was named, the court may appoint one. Identifying heirs. Heirs are confirmed based on the will or intestate succession laws. Debt settlement and asset distribution. All debts must be settled before assets are distributed to heirs. 6. Intestate succession. If there is no will, assets are distributed under intestate laws. First to children or to descendants, then to spouses, and if no direct descendants, parents, or ascendants inherit, other relatives inherit only if no closer heirs exist. 6. Intestate succession. If there is no will, assets are distributed under intestate laws. First to children or descendants, then to spouses, if no direct descendants, parents, or ascendants inherit. Other relatives inherit only if no closer heirs exist. 7. Taxation. Argentina does not impose inheritance tax at the federal level, but provincial taxes may apply in certain regions like Buenos Aires province and Entre Rios, which has a limited inheritance tax. So follow me for more information on Argentine testaments. And if you do have a testament, a will that was originated in the United States or in any English-speaking country, please contact us so that we evaluate it together with you and explore options. Thank you very much.